In the United States, a person on trial is said to be judged by a jury of their peers, but when it comes to jury selection, this isn't always the case, especially for those between the ages of 18 and those in their mid-20s. I sat down with Dr. Gerard, a former public defender, to get her take on why there seems to be an absence of young people in courtrooms.
If you do get selected for jury duty and you actually make it to the courthouse, typically trial attorneys such as myself, we don't value young people on a jury. And that is because most young people just haven't lived long enough to have a great deal of experience. And most young people are very passionate about what they believe in. They see the world really as black or white, and they feel very strongly about what's right and wrong. And in any type of trial, things are really gray. They're not so clear cut. And so as a trial attorney, we want older people with a little bit more wisdom. Maybe they have a little bit more empathy and compassion because they've lived and have seen things that the young people haven't seen. And we feel that they would weigh the evidence much more judiciously than a young person. And so even if you make it to a jury selection process, you're not likely to get picked because of that reason if you are young. Now, that's not to say that you're automatically disqualified. You're not. But as a general a practical matter in practice, as a trial attorney, I wouldn't necessarily want to take a young person. Typically, we like over 30. We like over 30 because, and it doesn't matter if you've gone to college, it doesn't matter if you've had children or the things that give you life experience. We just think people in their 30s, there's enough separation between adolescence and adulthood that would make people just have a level of sensitivity that some young people just don't have. And it's not a fault of being young. It's just you haven't had the wide range of experience that would make you more kind or more accepting. And that's really what we find. With age becomes wisdom, and we like that as trial attorneys.
Mr. Freed, a district attorney in Carlisle, agrees with Dr. Gerard, but only to a certain extent.
I can tell you on a personal level, when I'm the DA now, so I push a lot of paper rather than trying as many cases as I'd like to, and the ones that I do are big ones. But when I was doing a lot of cases, when I was young, and I started trying cases when I was 25 years old, I think, I would be sort of suspicious of young people simply because I remembered, being that age, and I think maybe not having the life experience that was necessary to make those decisions. On the other hand, as I've gotten older and I've learned more about trying cases, I've learned that that's not necessarily the case, and you have to look a little bit deeper into the person. So, if I have somebody, it doesn't matter what the age is, I want to know, does that person have any position of responsibility? Do they work? Are they decision makers? Because that's really, when it comes down to it, what we need on jurors is we need decision makers. Sometimes that's harder to determine with a young person because they don't have a lot of work experience. Maybe they're in school. It's a little easier to determine when I can see somebody's job or family status.
But a district attorney cannot handpick exactly who they want for a trial.
So the prosecution and defense, we don't have any say on who comes in. Like the courts, they do the roll, they do the names, and that's how they pick who comes in. Once that pool comes in, that's when we get involved with doing our selections. In the federal system, trials are frankly even more rare in federal court than they are in the state court. And if you consider where we are in Pennsylvania, we're in the Middle District of Pennsylvania, so that's 33 counties in Pennsylvania, and there's 3 different places with a courthouse: Harrisburg, Williamsport, maybe Scranton. Yeah, I don't think there's one in Wilkes-Barre. And then jurors get summoned from a larger county area into federal court. But I think it has more to do with the amount of cases that are getting tried.
32 million Americans get selected for jury duty each year, but only 8 million actually go. 3 million of those 32 just don't show up. By having only 25% of Americans to choose from, you're not always getting the most fair selection of people to attend a trial.
I think it depends where you are. where we are we're sort of a mid-sized, jurisdiction in Pennsylvania. Our people do a pretty good job tracking folks down. But I can tell you, if people don't show up, it's not often that we sort of send the sheriffs out to get them. And I think that's part of the process is you cast a wide net, and most people, really most people do manage their civic responsibilities and show up. We don't ask for much for your privilege of citizenship in the United States. It's one of the things we ask for. So we're fairly lucky around here. I would imagine in big cities it's a little tougher because people are more transient, and maybe it's a little harder to find them if they don't show up.
During his time as a district attorney, Mr. Freed has realized there's still some discrimination towards who gets picked just based off of looks.
I do some training for prosecutors, and one of the things I do training on is jury selection. And I saw a presentation much better than the one that I do by a woman who's a prosecutor educator out in the Midwest. And the point that she makes is sometimes you do in jury selection have to judge a book by its cover, because you only have a very limited amount of time, you have a very limited amount of information. Unless we're talking about like a capital murder case, we don't do individual voir dire, which is jury selection, so we don't do one-on-one. So we have a little book with a little form that was filled out, maybe have a chance to ask one or two questions, and then we as lawyers have to make a determination right then. So often the way people look will determine that choice one way or the other. Now also, how people act in the jury room too. If somebody's sitting there, I have two teenagers and a 10-year-old, right? And if somebody's sitting there like this and staring around like this and looking like they don't want to be there, I don't know that I want to pick a person who doesn't, who's giving off that kind of attitude. On the other hand, somebody who's very attentive, maybe shows up and looks like they're interested, you may get that vibe off a person too. You get more experience, you learn better how to do this, and maybe you don't so quickly judge a book by its cover. But often it's a gut call, and if somebody looks a little odd, and if they're odd and an outlier, that might be good for a certain case, it might be bad for a certain case. You just don't know.
And even if a younger person does get picked to enter a courtroom, it doesn't mean they'll be exactly a peer of the person on trial.
There are a lot of situations where the jury doesn't necessarily look exactly like the defendant, and that is simply related to our demographics. And of course, there are safeguards in the system to make sure that both sides of a case can't get rid of people for race reasons, religion reasons, things like that.
But handpicking who should and shouldn't sit on a trial is not as simple as just picking someone that seems to fit the description of a peer of the defendant.
It was like speed dating, but you were married to these people. You didn't have much time to get to know them, and yet you were going to be stuck with them, and they were going to decide whether the fate of your client. So I do agree that people should have, lawyers should have some say in who sits and who doesn't in terms of who gets selected. And the law allows you that if you can't be fair and impartial, this is a challenge for cause, that potential juror doesn't get to sit on the jury. But it's the peremptory challenges. Those are what we call golden arrows. I can get rid of anybody for any reason, but you have a limited number. I think that that's okay. But under the law, if you're a prosecutor, you can't use those golden arrows to get rid of people based on race or gender. But in reality, we see prosecutors doing that over and over and over again.
So when asked if there was a bias towards young people being excluded from courtrooms, Dr. Gerard had already made up her mind.
There's no question. I mean, I will direct you to the Snyder versus Louisiana case. I will also direct you to, it's called Miller L. versus Cockerell, I think. And it's a Texas case. And this will give you sort of the history of the long history of systemic discrimination against people of color, particularly in death penalty cases, where prosecutors are essentially stacking the deck to get the verdict that they want. So I'm using that as an example, but you're saying it could be youth, it could be someone who's tatted up, it could be someone who comes into court not wearing the right clothes. It's people make assumptions based on what religion you are or how much income you make. And so we make these shortcuts that really do a disservice. We make these shortcuts about who people are that do people a disservice because, of course, they could be perfectly qualified to sit on a jury and make a fair and impartial decision based on the evidence. And we've already eliminated them because of who we think they are.
It's clear that young people are being discriminated from courtrooms for multiple reasons. But if a person on trial is to be judged by their true peers, then the way jurors are selected will have to change.